Good afternoon, everybody. My name is Dean Bernard, and I am here with Jim Casey from Field Law. And we're here to have a discussion today about Jim's new book. I think he has a copy of it here, The Law of Regulatory Investigations. And we're going to have a little discussion about it. Jim's going to share with us some of the insights around his book. So, Jim, welcome.
Thank you.
So, tell us a little bit about the book.
Yeah, so this is it, Dean, hot off the press this spring. We wrote it with my co-authors, Jason Cully and Michelle Casey. And really the impetus for it was that there's a lot of good sources for hearings, for the adjudicative phase of the regulatory world. But we found there wasn't a really good source for investigation. So we thought, let's go deep into the subject. And of course, if you have one hearing, you probably have 10 or 15 investigations. And as you know, there are many interesting and challenging legal issues involved in investigations. So that was the book. That was the impetus for it. And it's designed for both administrative law lawyers, but also for regulators who have to manage investigations. It's available LexisNexis on store or online store.
That's great. And I would agree. I mean, it's great to see a reference for those of us who are on the front lines of investigation. It's great to have a reference like that. So what do you think are some of the key developments in case law that are going to concern regulators and regulatory investigations over the coming years?
Yeah, so looking back over the last number of decades, there's four that I would highlight, Dean. Number one, I would say the Canadian Charter of Rights and Freedoms, because when it was introduced into Canada, there was a real uncertainty of how it would affect administrative investigation, regulatory investigations. Because, for example, in the criminal law, we know that the Charter provides a right to silence, a right to not cooperate. Again, in the regulatory world, we can compel statements, we can compel cooperation. And so we thought, how is the Charter going to affect this part of our world, which is so integral to the regulatory process? And what the court said is that we're not going to approach investigations in the regulatory world the same as a criminal investigations, because it's different. It's not like a search and seizure in a criminal process. These people are working in a regulatory environment. They know they need to cooperate. They know the rules of the road, and part of it is the obligation to account to your regulator. So the Charter developed in a very different way that did not really impede regulatory investigation. So that's one. Second thing, looking back, that I think is absolutely critical is the duty to be fair. So eventually the courts began to recognize a duty to be fair in the investigative stage. And that was essential to make sure that the process is fair for the investigative member with so much at stake. Now, third, if there was too high a duty in the investigative stage of the duty to be fair, that could impede investigations. So the court said there is a duty to be fair, but it's not at the same level as you would have in a hearing. And fourth, Stinchcombe disclosure. So as you know, the criminal law, Stinchcombe disclosure, you're looking to investigate to find not information for a prosecution, but all information both for and against a investigative member, and then disclose everything to the investigative member. And when that began to be applied to regulatory investigations, I think that was a very positive step in ensuring fairness in the investigative stage.
Right. No, those are all very interesting. In fact,
what do you think, Dean?
Well, it's interesting because the disclosure one is interesting to me. As external investigators, we work with a lot of different regulators, and while some of them take the position that we're going to disclose everything we gather at the investigative stage before we seek the input of the person being investigated, others do not.
Yeah.
And so it's a bit of and sometimes we have defense counsel who insist upon it, and when the regulator is saying no. So I do think that it's going to be interesting to see over the course of the next few years, how is all of that going to get ironed out?
Yeah.
Because for us on the front line having to deal with these questions, it can be a challenge.
Absolutely.
Yeah. So tell me a little bit more about some of the important legal issues that you think are going to be addressed in the future.
I think one of the most important issues is related to this. I'm going to get it out of my pocket. It's our phones, it's our tablets, it's our desktop, it's our laptops. Because all of these devices contain all our professional information, and it might have information that's relevant in an investigation. A regulator might want to get this phone if I was a subject of investigation. but it also contains all my personal information that
Right.
is immaterial to the investigation. And when documents or when devices are seized that contain a mixture of personal information and professional information, it creates real challenges. So that's one. The other thing, Dean, the other big issue I think that's coming in the years ahead, we had a great session this morning on trauma-informed investigations. So I think the issue will be how regulators do a trauma-informed investigation while still ensuring an appearance of impartiality, not just actual impartiality, an appearance, and ensure that there's no breach of the duty of fairness. I think they're completely reconcilable. You can do trauma-informed investigations and be fair and impartial, but there's some delicacy to it. So those are two big ones from my perspective. For you, on the front lines of investigations?
Well, the trauma informed piece, absolutely. I agree with you. I mean, I think it's interesting too that with our trauma informed approach to things, that trauma informed approach needs to apply to everybody involved. There tends to be a bit of a thinking that, well, it's just about quote unquote victims.
Yeah.
But that's where the fairness piece comes in. But the other one for me is technology, as you've said. What about AI?
Yeah.
What about the ways in which people will practice professions differently related to the technology they have available to them, and being able to ensure that that's being done ethically and professionally. So it's going to change the whole landscape, not only in terms of how we investigate, but even the nature of the things we do investigate.
Right.
Yeah,
Very interesting.
Now, just as we wrap up, do you have any final thoughts on any of these things, or some more nuggets you can share with us?
Well, from my perspective, a thorough, comprehensive, fair, and impartial investigation advances and protects the public interest. And a fair, impartial, thorough investigation also serves as a bedrock for a good hearing. It's the foundation. So important, as you know. So that was the impetus for the book. How about you?
Well, I couldn't agree more. I mean, I think that it is all about fairness, and this book is a great guide. In fact, my company bought a couple of them,
Right.
Because it offers, and even if you're not, I know that a lot of this focuses on actually, you tell me, some of this focuses on the province of Alberta, right? But
it's cross Canada.
Exactly. I see in the book how applicable it is to all the provinces, and so it's really helpful to us to work with that. It's a great book. I couldn't recommend it more highly. I want to thank you so much for taking the time to meet with us and share your thoughts on that. And like I said, folks, get a copy of the book. It's worth having. So thanks, Jim.
Thank you, Dean.